Please be seated. Our next case is West Florida Regional Medical Center versus C.
Good morning, Your Honor. Steve Bronis appearing on behalf of West Florida Regional Medical Center. The trial court's February 6th and February 9th orders require the hospital to produce two categories of documents: general credentialing records and adverse medical incident records. The February 9th order requires the production of records from the credentialing files of the hospital of the training and education of Drs. Benson and Reese, and for a blank application for medical staff privileges. Prior to Amendment 7, all records which are part of the credentialing process were privileged and confidential. Not only did that include the completed application package for staff privileges, but also blank forms used by the hospital to evaluate caregivers. Amendment 7 narrows the category of documents which are exempt from discovery by requiring the disclosure of medical reports of adverse medical incidents, even if they're contained in credentialing files, by requiring the production of records which are not reports of adverse medical incidents. The February 9th order is beyond the scope of Amendment 7. The 2nd and 3rd districts in Shabazz and Garcia have held that Amendment 7 does not permit this form of discovery. And Avante Villa versus Breedart, as well as other cases, this court has said that the proper interpretation of a constitutional amendment must begin with an examination of its plain language. Amendment 7's plain language compels the conclusion that it was enacted to require the production of records that contain information of specific adverse medical incidents and not general credentialing material. Amendment 7 plainly states that its purpose is to create a right of access to records of a healthcare facility or provider's adverse medical incidents. The ballot summary is equally clear, stating the amendment gives the right to patients to records of adverse medical incidents, including those which could cause injury or death. This court in Bowen observed that the amendment has but one purpose: providing access to records on adverse medical incidents, and concluded that the amendment was self-executing because it provides a sufficient rule by which patients can access records of adverse incidents. And
the Florida, with regards to the work product doctrine,
yes,
how can we be sure that the trial court even reached the work product issue, right, since the order is silent as to the applicability of the work product doctrine?
Right. That relates to the 2nd order, Judge Lewis. That's the February 6th order, which requires the hospital to produce all records of adverse incidents for all patients of Drs. Benson and Reese for 2 years preceding the surgery on the plaintiff. And there are 3 reasons why that order exceeds the essential requirements of the law. To answer your question, Judge Lewis, we had requested the opportunity to file a privilege log after the court ruled on the scope of discovery to determine whether or not any of the documents that would be found during a search would be work product, to identify those documents on a work product or a privilege log, and to categorize them as the type of privilege. And you're right, we don't know as we sit here whether any of the documents in that universe of documents would be put on a privilege log, or even what that privilege is. Would they be attorney-client privilege? Would they be opinion work product? Would they be fact work product? Or
do you believe you have been denied that right under this
order?
Because it really is silent.
But it orders us to produce the records to the respondent's counsel. It doesn't say, and other orders I have seen have said precisely this, that we are to produce any records within X number of days that are responsive, or provide a privilege log to the court with respect to those records, labeling those documents, and have the court conduct an in-camera review of those records. The court
Would you be
did
happy
not,
if the court clarified the order to say that?
we asked for clarification and modification, and the court denied that motion. With respect to work product, Your Honor, that answers that question. There are two other reasons, though, why that February 6th order does not meet the essential requirements of the law. The court in that order, as I said, ordered the production of all records for all patients for all adverse incidents of Dr. Benson and Reese. The order exceeds the scope of the written request of the plaintiff and as modified at the hearing in July. We go back to item 22 of the written request, which is the request at issue. In that request, the respondents asked for records of adverse incidents for the two doctors pertaining to gallbladder surgery and R&Y surgery, not records for all adverse incidents for all patients as ordered by the court. At the hearing in July, counsel for the respondents stated that because of the costs associated with searching for records of other patients, he was limiting his request to the adverse incident records of this particular incident involving the plaintiff. And let me read from the record. It's at Appendix 761. Mr. Bronis, well, does that mean he's withdrawing request number 22, which we interpret as asking for records of investigations of any adverse incident? The court, Mr. Staples. Mr. Staples, counsel for the plaintiff. I'm not necessarily interested in other incidents. I'll limit it to this particular incident, the one on Lynda C. Furthermore, the order does not provide for the hospital's statutory right to require payment of reasonable costs in advance for searching, retrieving, reviewing, and redacting responsive records.
I looked at these two orders, and it appears it's just silent as to that statutory
Precisely, and
entitlement. Did you go back and ask for that clarification?
Yes, that was part of our request for clarification and modification.
So you interpret that as a denial of your entitlement to get advance costs?
Unless this court says to the trial court on remand, provide for them to get costs. And Mr. Burlington sent a notice of supplemental authority, I think it was last week, the case of Columbia Hospital versus Fain, F-I-A-N, and in that very case, the same exact issue arose. And the court in Fain found that 381.027C1, which is the statutory provision that gives the hospital the right to get costs paid in advance, was found consistent with Amendment 7 and constitutional by the Supreme Court in Buster, and in their order provided that the hospital is not required to produce material prior to payment. With respect,
How does that comport with the general notion on cert review of discovery orders that if it's expensive for a party, that really isn't our concern?
well, because the statute was put in place by the legislature as part of a comprehensive statute on how Amendment 7 could get effectuated. Because courts have said that it's costly, it's expensive, and when we argued the Buster case before the Florida Supreme Court, we tried to make the court aware of just how voluminous the records are that have to be searched, and they have to be done not by anybody, but by somebody professional enough to know where to look, what adverse medical incident records to look for, how to review them, how to redact them for 18 different HIPAA factors. The Florida Supreme Court looked
I
at
think
that.
your record here indicates from 10,000 to 25,000 records.
That's right, Your Honor, because they're not, the hospital can't push a button and say, give me the adverse medical incident records of X or Y or Z.
Counsel, with regards to your cost issue,
Yes.
would this issue alone be appropriate for cert review?
No, not in and of itself, probably not, although I do think it could not be effectively remedied on appeal for the reason that we're entitled to the costs in advance.
Well, can you cite to any case that holds that if an issue is appropriate for cert review, then a party may piggyback on top of that issue another issue that is not appropriate for cert review by this court?
All I can address in answer to that question is the Columbia Hospital versus Fain case that came to the court. The 4th District just issued their opinion last week in identical circumstances, from the work product issue to the non-payment of costs issue. Those were the key factors in the Fain case, and the court remanded or sent it, when it sent it back, it said we would have an opportunity to file a privilege log, and we would be entitled to our costs.
Is there any analogy between that and the Supreme Court's right upon cert review to have pendant-like jurisdiction of
Yes,
the
Your
issue in a
Honor.
case?
I think so. I think so. With the court's permission, I'll reserve the balance of my time.
May it please the court, I am Philip Burlington here on behalf of respondents. First, let me apologize for not being Charles Bell. Apparently, and I did not know this when I agreed to do the oral argument, there had been a prior motion to continue this oral argument because plaintiff's counsel had contacted an appellate lawyer in Pensacola to do it, and he could not make the original date. I did not know that, and I became involved about 10 days ago, and I hope the court will not take offense. I believe the motion was filed in good faith by trial counsel, but they decided it might be more useful to have me argue it. I've been arguing Amendment 7 about as long as my esteemed colleague here, so hopefully it will be of some benefit to the court. I did cite supplemental authority last week, and I just want to touch briefly on it. Columbia Hospital addresses 3 of the issues that were raised before this court and is the first appellate decision to do so. One deals with the HCQIA and whether it preempts Amendment 7, which is obviously a threshold consideration for you. The 4th District rejected that preemption argument. The only thing I would add to strengthen that opinion, which basically follows our argument here, is that if you look in the Buster Supreme Court decision, it notes Federal Court of Appeals decisions that hold that state peer review privilege is not given any effect in federal court in federal causes of action. So obviously there is no federal peer review privilege either under the HCQIA nor under any other provision.
Counsel, with regards to the preemption issue, in Kruger versus Love, the Florida Supreme Court noted that without confidentiality, information necessary to the peer review process could not be obtained. Should that statement affect our analysis of the preemption issue?
No, because that was a reflection of the legislative intent underlying the statutes that the Supreme Court was construing in that case. As clearly stated in the Buster Supreme Court opinion when they quoted from the 5th District Buster decision, the people through the referendum process are entitled to establish public policy on issues such as this, and they have determined that that confidentiality is not necessary and must yield to the greater interest of patients' knowledge and the perception that, in fact, what was happening was medical negligence was being hidden. Doctors who were not either competent or had a history of being incompetent were being shielded, and I would note that that was actually the underlying premise of the federal passage of the HCQIA, where the Congress made specific findings that medical malpractice was causing such significant problems nationwide that it was necessary to establish a national data bank. So I do not believe that the public policy concerns expressed therein can apply here. It was proper in that case because it was legislation being construed. I want to touch on one thing on the impairment of contract. Again, Columbia Hospital has addressed that very well. The one thing that is significant to this case, I believe, in addition to that, is if you look at Section 12.2 of the bylaws that are at issue here, and they're quoted, I believe, in both petitions, all it does is require the physicians to respect confidentiality, quote, to the fullest extent of the law. So therefore, when Amendment 7 passed, there was in fact no conflict because the law had changed, and at this point, confidentiality no longer exists with respect to what Amendment 7 allows. Now, to deal with the more specific issues in this case, the second order was addressed first, which is the February 9th order that authorized us to obtain a blank application form for medical staff privileges and information regarding residency and postgraduate training for the Roux-en-Y procedure for the two defendants. Now, I would take the position that order does not implicate Amendment 7 at all. There were requests for credentialing independent of Amendment 7. I would
Counsel,
note...
is there any evidence in this record that the credentialing committee created the blank form?
I'm sorry, any evidence who created it?
That the credentialing committee itself created the blank form.
There is no evidence of who created it. I do believe it's attributable to the hospital. But I would note that the one statute which deals with credentialing privileges, which is 395.0191, which is what they rely on as protecting those documents. With respect to the blank form, subsection 5 of that statute states that the governing board of each licensed facility shall set standards and procedures to be applied by the licensed facility and its medical staff in considering and acting upon applications for staff membership or clinical privileges. The next sentence says, these standards and procedures shall be available for public inspection. Now, this is to be distinguished from peer review. And there's a 4th District case, Tenet Healthcare Systems, which they rely heavily on, which was a peer review case. The peer review statute does not have any such provision. But the credentialing statute makes it very clear that the standards and procedures for applications for medical staff shall be available for public inspection. So that's the statute they rely on. Clearly, it seems to me, the blank application form falls within what is intended to be available for public inspection. As to the records of residency postgraduate training, I would note subsection 8 of that same statute, while protecting the proceedings themselves regarding credentialing, says that information, documents, or records otherwise available from original sources are not to be construed as immune from discovery merely because they were presented during proceedings of such board.
Counsel, what is the adverse medical incident that the records of doctor training is related to?
Well, the adverse medical, there's two levels to my answer. The first is, in this case, the procedure that we were seeking information on was done on our client, and we allege negligently resulted in not only harm, but the need for additional surgery, and as alleged in the complaint, the current need for a liver transplant. So that would be an adverse incident in itself. Now, we have argued in our response that that a negligent credentialing decision also qualifies as an adverse medical incident under Amendment 7. And I would note that the language of the amendment talks about, and it defines...
Counsel, but the procedure that was done to your client is an alleged adverse medical incident. It has not been established.
Of course not. I agree, Your Honor. However, the definition of adverse medical incident in the constitutional provision talks about medical negligence, intentional misconduct, not at issue here, any other act, neglect, or default of a healthcare facility or healthcare provider that caused or could have caused injury or death. Now, negligent credentialing is a recognized form of medical negligence. We have alleged that as a separate count in this case. We believe that we fall within this definition, and I will also note the 5th District decision in Buster talks about how constitutional provisions are to be construed even more broadly than statutes to effectuate the interest of the public, in this case, who passed this by referendum. So it's our position that negligent credentialing, and I agree with your question, Judge Lewis, that at this point we've only alleged the adverse medical incidents as to our client individually, and we've also alleged the medical negligent credentialing, which is a more generic form of medical negligence. But there's no case
that says that medical negligent credentialing is a cause of action in tort.
Yes, it is recognized.
Because, I mean, as you're saying this, it kind of sounds like a way to work around the limitation in Amendment 7 to adverse medical incidents.
Well, I believe that
otherwise it's fairly hard to understand how hiring somebody who may not have had training to do a certain, maybe the doctors didn't have training to do certain procedures, but then maybe they did those procedures. Is that your point?
Yes, that is the fundamental premise of a negligent credentialing, is that the hospital, who has the obligation to determine the adequacy of the training to perform. For example, if somebody was an OBGYN, the hospital would not authorize that doctor to perform lung surgery and so forth. There are established criteria, not only in the statute saying there's an obligation on a licensed facility, but under things such as, I believe they call it JACO, which is the Joint Accreditation Organization of Hospitals. There are recognized standards for this, and it's our position that this particular procedure, which is a very specialized procedure, should not have been done by these two doctors. They weren't qualified to do it, and that is a form of negligence. And that form of negligence preceded Amendment 7, so I don't think, while it obviously has to be evaluated in the context of Amendment 7, I don't think we can say that it was done in order to somehow bring Amendment 7 into a broader application. I would note that Chavez, Garcia, none of those cases say that all credentialing files are immune from Amendment 7. They all say it has to be limited to that which would show adverse medical incidents as defined in the constitutional provision. So while it may be necessary for a judge to evaluate them in an in-camera inspection, as other documents that would otherwise be privileged may have to be examined, that does not eliminate them entirely from being available under the constitutional provision. As to the costs, the orders, the February 6th order is the one that deals with Amendment 7. It did not specifically address cost. And I would note that they produced apparently at some point an invoice for $21,000, which they said was necessary to get started. And I don't believe that was in the affidavit they submitted of their risk manager, and I'm not sure if the record's clear when that was submitted. That is what triggered, and I believe it was very close to the time of the hearing, my trial lawyer essentially backpedaling, and I would take the position he did not stipulate clearly to saying only this incident, because if you look at pages 7, I believe it's 745 and 46, when the trial judge suggested maybe we can eliminate some issues, plaintiff, what is the scope of your request, plaintiff's lawyer talked about, well, I'll be glad in light of this expense to go back and limit my demand. I'm not interested in certain things. And he was sort of making determinations on the fly, trying to evaluate cost. I don't think there was a stipulation that he could equitably be bound to, that he was limiting it to this one incident. But the
argument that, and it appears to be much broadened in this order than the request, that there were requests for incident reports
correct.
With respect to specific items, and this order appears to open Pandora's box to whatever.
Well, Judge, there's no question the order was broader than the discovery request. Whether that warrants...
If it's broader than the discovery request, what authority does the judge have to order?
Well, Judge, first of all, it seems to me that if the argument is identical, which is Amendment 7, I mean, there's cases that hold we can get Amendment 7 materials regardless of relevancy and burdensomeness, and that's well established in Chavez, in the Columbia case. So it isn't like a normal discovery request. But to warrant certiorari review, it hasn't even been established that such documents exist beyond the scope. But my trial lawyers would be willing. We understand. We asked for it relating to the two procedures. One was the laparoscopic gallbladder, and the other one. We'd be willing to limit it to that.
The other one, that's the name that's that long.
It is that long, and I can't pronounce it.
In the middle of it.
I can't pronounce either of them, quite frankly. So the Roux-en-Y is as far as I get. But It was broader. There was no prejudice to them in the sense that there's no other argument they could have made in the sense of Amendment 7. They couldn't argue relevancy. They couldn't argue burdensomeness. But 2 years as to 2 doctors for adverse medical incidents should not be burdensome. That, unless they're very, very bad doctors. We're not talking about...
If it is, the plaintiff has a real good case, I guess.
Yes, I believe you are right, Judge.
Let me ask you a question about your motion before you run out of time here to consider all other aspects of these, you know what I'm going to ask you.
Yes, I know what you're going to ask me.
Because, as I understand certiorari, it's either an up or down thing. We're either going to deny the petition or we're going to quash the order. We're not going to remand this to the trial court with a whole bunch of instructions as we would in a plenary appeal from a final order. And you don't really have situations where you can piggyback other things, like in review of a final order where everything is open for review up to that point. You don't really have that. We're just reviewing the correctness or incorrectness of the order that is the subject of the petition. So how do you bring before the court all these other orders?
Well, the issues that were raised in those motions are in these 2 orders, February 6th, February 9th. The only difference is the trial counsel filed a rehearing as they did, but did not get a ruling until much later. But the issues he's raising regarding the limitations on the deposition of the CEO were ruled on by the judge in the February 9th order. So technically that was before the court. But even in a non-final appeal, this court has authority.
It's not a non-final appeal. It's a certiorari petition.
Oh, I agree.
If I understood Haines City v. Higgs and other cases correctly, it's either quashed or it's denied. We're not going to sit here and do some sort of reconstruction of the thing by remanding to agree with this and disagree with that. Or courts have done that, to be sure.
Yes,
I know they've done it. But the Supreme Court has said that one of the things that distinguishes certiorari from non-final order appeals, it's either an up or down vote. You either deny it or you quash it. You don't remand it with instructions. I mean, it's not like a final appeal.
But, I mean, you can determine that only certain aspects of the order depart from the essential requirements of the law.
I guess that's correct. I mean,
so
I guess
there
you
is
could...
an ability to parse somewhat.
Right,
but I understand, Your Honor, the motion is somewhat unusual. And it's in the nature of an untimely cross-appeal. I recognize that. As to costs, I just want to notice one thing. Under 1.280, which deals with document production and other forms of discovery, a trial court is granted discretion regarding the allocation of burdens as to expense, to narrowing the scope. The trial court under subsection C is granted discretion. This statute...
Counsel, in regards to the cost issue, would you explain how the trial court's silence as to the hospital's right to require advance payment of costs precludes the hospital from demanding such requirement?
Well, the trial judge did not rule on it. I do not believe it rises to the level of certiorari review. They only came in with an interim bill, so to speak. Now, the statute says that they are entitled to require it prior to, I believe, even starting the search. It's our position that that provision is inconsistent with 1.280C, which gives the trial court discretion on discovery matters to allocate burdens, to determine what would be an appropriate expense or what other conditions should be imposed. They've cited the Williams case that says it has to be direct conflict in order to be a violation of the court's rulemaking authority. But if you look in Williams, there's a case called Haven Federal Savings, which is a mortgage foreclosure case. The legislature had enacted a provision making counterclaims, mandating them to be severed. The Florida Supreme Court held that violated the court's rulemaking authority because it denied the trial court's discretion on that matter, which was contained in the rules of civil procedure. So I would take the position that if you reach that point, it is a violation of the rulemaking authority because it denies the trial court any discretion, puts it entirely in the ballpark of a party to determine when it will be paid and how much. And we would submit that for that reason, that imposition was properly left out of the trial judge's order. Thank you.
Let me address it sort of backwards and start with this cost issue, because respondents made the same sort of argument at the trial court level, That's that the statute does not apply in the context of discovery requests in litigation. Well, that argument is contradicted by the statute's plain language and the fact that the Florida Supreme Court specifically upheld that language in the Buster case, which involved a discovery request coming in litigation. And in the Fain case last week, the 4th District declined to impose a distinction between Amendment 7 requests made in a pending case and those made outside the context of litigation. With respect to the credentialing issue, counsel now says this request for credentialing material really wasn't an Amendment 7 request. Again, I'm referring to the record, Appendix 0746-0747. This is Mr. Staple, plaintiff's counsel. So what I would suggest, what I would ask the court to do is that we're entitled to the credentialing documents under Amendment 7. Indeed, that's the only way they could get them before Amendment 7 was enacted. These credentialing documents that were part of the credentialing process.
What do you say, though, to Mr. Burlington's argument that with respect to these training, in the one case, the training records are essentially part and parcel of an adverse incident request?
I'm glad Your Honor asked that question, because the matter with respect to the related to the adverse incident, related to, I submit to the court, does not mean relevant to a specific cause of action or theory of liability. Related to an adverse medical incident means records about or involving a specific adverse incident of a patient, not related to a cause of action. Alleging negligent credentialing does not change the plain language of the amendment. There's nothing in the text of Amendment 7 or any case law which says that a cause of action determines the scope of an amendment, the amendment. Let me give you an example of what I think related to means. A medical event causes the death of a patient. That would be an adverse incident. Documents containing information about that event, such as the peer review investigation of the incident, the risk management report of the incident, the Code 15 report filed with ACA of the incident, are documents related to that adverse incident. They would have you redefine the entire scope of Amendment 7. Lastly, and with respect to the constitutional issue.
Counsel, let's digress for a moment again. Back to the blank application form.
Yes.
Isn't it the information provided on the application form itself and not a blank form that the credentialing committee considers?
No, Your Honor. The blank form is different than what the medical staff bylaws and rules and regulations, which describe how a doctor gets privileges. That is a public record. But this is an application form that's used by the hospital to determine what questions they're going to ask applicants, to determine their competency and evaluate them as caregivers. That is precisely the kind of form in Tenant Healthcare versus Titel that the 4th District held was confidential and privileged because it was part of the entire process. Thank you.
You still have some additional time. We extended their time about 2 minutes. So
okay.
Something else you need?
Yes, I wanted to talk about this Hickey issue because I think the court in Fain got it wrong. They recognized it was an obstacle preemption argument, that Amendment 7 as interpreted in Buster it creates obstacle preemption with the Healthcare Quality Improvement Act, but then recognizing it as obstacle preemption, they treated it as an express preemption. In Holly versus Auld, the Florida Supreme Court recognized the fact that meaningful peer review would not be possible without a limited degree of confidentiality for the process. That confidentiality, as recognized in the Fain case last week, has been abolished by Amendment 7. And the question really is, does that create an obstacle for the Federal Healthcare Quality Improvement Act, which was expressly passed by Congress to prevent doctors, bad doctors, from moving from state to state and hospital to hospital? And that act depends on effective peer review being conducted. Because what the hospitals do is they conduct the peer review. If they find a doctor has committed malpractice or should otherwise be disciplined for longer than 30 days, they have to file a report with the National Practitioner Data Bank of that fact and what they found. And then every hospital has to trigger that bank regarding any new applicant, and every doctor every 2 years. As a practical matter, if the hospital cannot provide reliable information concerning disciplinary actions of doctors, it stands as an obstacle to the Healthcare Quality Improvement Act. Thank you.
That concludes our case.